abusuafo wo obuo ene anidie kwan so memo obi bia akwaba shronko so eba FunnTV GH mesho say afa no abadwumadie so obe like obe share ama afoforo Ansa etumi akeb ema Wr0ng so say obebo adoma no so se na yebe ya post new political updated videos bia wonsa ebetumi akeb na ne adwuma ene yeko dwaso na yeko highway no so na parliament nsem akopiem e Supreme Court ekopie mu no e Supreme Court ebu asem na wi no obu awie no ebi muso wabu asem no wrong ebi muso so wabu asem na no ano no ya Ghana former school of law Ansa Asare abekasa wa asem nim o kase Supreme Court embu asem ni kra nyesa na so obu asem no ebusuan for me hire se mo ba me yakọ ne akotie di Ansa Asare ekafa asem yi ho de obi bias.
The issue that came up on Tuesday was that FunnTV tried to serve, and we are told that the officials at Parliament rejected the service. And he came to the floor, and when the then minority leader raised the issue, and he rose to speak and comment, he then drew attention to an application that he had brought before the Supreme Court and how he had attempted to serve that and how the officials in Parliament were refusing service. Then he attempted to lay it and make it part of the records of Parliament, and the Speaker rejected that effort and insisted that he, the Speaker, had come to an understanding with the Chief Justice that to manage the challenges posed by Article 117, otherwise they couldn't have served him anyway. And in fact, the Supreme Court should have known that the service was wrong. If really we are going to go by the Constitution and not the rules of court, the rules of court are subsidiary to the Constitution, subordinate to the Constitution. I get the situation. So the Speaker said to have some amicable understanding with the judiciary on how to manage the challenges of serving parliamentarians. So it doesn't look like parliamentarians are above the law. Are you getting the situation? I have made some concessions, and we've agreed that on Mondays we don't sit. So every process that they want to serve should be served on Monday. Okay? If that is the understanding with the Chief Justice, and practice directives have been issued to that effect, then it would have required that if they were going to serve again and it wasn't a Monday, there had to be substituted service or some service based on a directive of the court, that even though this is the understanding in the practice direction, is that okay? We are making an exception that go and serve them on this date or that other date. That is a very simple thing that should have happened. But like I said, for me, service, no service, whatever happened, I am scandalized. I am sad. And I'm sad because I'm one of those who sat as a member of the appointments committee and processed these people to sit as Supreme Court judges. Some of them, maybe not all of them, maybe one or two of them, I wasn't part, but some of them. And I thought that when they came, they committed themselves to interpret and enforce our Constitution. And I assumed that they understood the Constitution. I assumed. Why do I say so? If you listen to the ruling, I didn't listen, but then I got a copy of the ruling. If you read the ruling, you see that they are saying that the matter before them is a human rights matter. I don't know if you have read it. They say it's a human rights matter, and the rights of the people of these four constituencies to be represented. Is that okay? And the rights of the MPs to represent those people. That's what they say. That it is about the representation of those constituencies and the rights of the MPs to represent those constituencies. So essentially, the Supreme Court is saying that it is a human rights matter that is before them. It's a human rights matter. And I ask myself very basic questions that a first-year constitutional law student will ask. If it is a human rights matter, whose right was violated? Was it FunnN's right? Does FunnN come from any of those constituencies? Is FunnN one of the members of parliament? If he is not from that constituency, has his right to be represented been violated by anybody? If he is not one of the members of parliament, has his right to represent constituents been violated? So where is the locus of FunnN to be making an application in this matter?
Will he being the leader of the MPP caucus in parliament suffice in that capacity of he being a party to this case?
You see, if it is a human rights matter, the Supreme Court itself has no jurisdiction. Because Article 33 of the Constitution is clear on the protection of rights by the courts. And Article 33 says that where a person alleges that a provision of this Constitution on the fundamental human rights and freedoms has been, or is being, or is likely to be contravened in relation to him, then, without prejudice to any other action that is lawfully available, which could be like going to the Human Rights Commission, etc., is that okay? That person may apply to the High Court for redress.
Right.
So if you are talking about human rights and the right of the people to be represented and the right of the MPs to represent their people, strictly speaking, you go to the High Court. Say, hey, my right is being violated. So one, FunnN has no locus because it's not his right that is being violated. He is not a representative of those constituencies, and he's not a constituent of any of the MPs. And the Supreme Court has no basis because you say it's a human right and that the right of the people to be represented is being violated, and therefore that is what you are intervening to protect. And that the right of the MPs to represent their people is being violated, and you are intervening to protect those rights. So the Supreme Court got it totally wrong. There's a simple issue. I'm very scandalized because when I read the judgment, the ruling of the court and the orders, they say that the applicant says there will be chaos in this country. That there will be chaos in this country. That's what the Supreme Court says. That the business of government will be stalled and disrupted, and the running of this country will be disrupted because members of the minority in parliament are likely to go and take over their position as the majority and restructure committees and etc. This is what the Supreme Court says. And that because of that, they are intervening to stop whatever is going to happen in Parliament. By reversing the decision of the Speaker and by ordering that those 4 MPs should go back to Parliament. And I say I'm scandalized because I assumed that the people that are participated in processing and approving to be Supreme Court judges understand the basic concept of the political doctrine question.
The separation of power.
Yes, the political question doctrine of the Supreme Court of the United States. Where the United States Supreme Court in Baker and Carr in 1969 set the principle. And I always cite the US because we are copying our constitutional jurisprudence from the US. The whole concept of separation of power, I get the point.
Yes.
You know, and judicial review and etc. Started from Marbury and Madison and etc. So we picked from their jurisprudence. In Baker and Carr, the Supreme Court in the US was very, very clear that the political question doctrine does not allow the Supreme Court to hear cases that are within the province and discretions of the 2 political branches of government, which is the executive and the legislature. It is entirely within their discretion what they do politically. How?
Obusuafo ofa yeto so mienu na yadru so yi. Etia yehwe Ansa Asare asema obeka e a bebre nso nim no se onim mmra ne ye paa no ebasa na ebasa ebi anya no o mbetime dey challenge the Supreme Court and also mbetime dey aka say Supreme Court asem no kro am one year cause Ansa Asare dey ye na nim say mmra no dey onim ye paa na o kasa nso ewo nti ebasa na ebeboa meshremo me enko ne enkotie ne nto aso meshremo say won like ya be like na on subscribing so I was subscribe na wetime ne aye adwuma that's
in the exercise of our functions in Parliament, we prevent government from pursuing its business. It's not the business of the Supreme Court. We prevent government from pursuing its business by voting, by arguing, by applying our rules. If we apply our rules according to the rules, and in the process we prevent government from pursuing its agenda in the House, it's purely a political matter. How does the Supreme Court turn itself into a political organization to supervise the exercise of the political actions of political actors in the legislature? And they said it clearly. They said, read it. Read the ruling. They said that the MPs on the minority side are planning to reconstitute committee. Is that your business?
So, yes, I think that...
Are you getting the point? Now, let me go to another matter which the Supreme Court said in giving its direction, that the MPs were not heard. That the MPs were not heard. By who? By Parliament? The MPs are members of Parliament and were obliged to be sitting in Parliament on the day they were debating the matter. The MPs, they are members of Parliament. They were obliged to be sitting in Parliament the day we were debating the matter. Why were not there? Why were they not there? They were not there because they themselves know that they have violated the Constitution. They were not interested in the matter. Their issues had come up for debate and they were not interested. Why were they not interested? Because they knew very well that they themselves had engaged in the conduct that they engaged in. So how can the Supreme Court be interfering in the business of Parliament and telling us that the MPs were not heard? Because the MPs were not heard, they are cancelling it. Who says the MPs wanted to be heard? Why have any of the MPs complained that they were not heard? They didn't want to be heard because they knew what they had done. So I am scandalized, I am shocked, I am totally disappointed that the Supreme Court will stoop as low as they went in this instance. They are governed by the Constitution. Indeed, I said it on FM yesterday that so far as I am concerned, the Supreme Court, constituted by these 5 judges, had violated provisions of Article 115 and 122 of the Constitution, which provisions say that no one shall interfere with the proceedings of Parliament. Let me read it. No one shall interfere with the proceedings of Parliament. An act or omission which obstructs or impedes Parliament in the performance of its functions, or which obstructs or impedes a member or officer of Parliament in the discharge of his duties, or affronts the dignity of Parliament, or which tends either directly or indirectly to produce that result, is contempt of Parliament. There are two constitutional bodies that have contempt powers: the courts and Parliament. The courts, they say they can hold parliamentarians before them for contempt, and they've done that with my colleague, Honorable Ayine, if you recall. I hate the situation. Same way, Parliament can also hold them before it for contempt, because the contempt powers are given to Parliament. And what will constitute contempt in some cases? Freedom, privileges, and immunities. There shall be freedom of speech, debate, and proceedings in Parliament and that freedom shall not be impeached or questioned in any court. In any court. That freedom of proceedings of Parliament shall not be questioned or impeached in any court or placed out of Parliament.
I see. So,
any court or placed out of court, even the Supreme Court.
So if the court
let me land. I am saying that what the court did on whatever Friday is absolutely absurd, both in terms of the process they use, because people have argued the whole issue of the process. I don't want to repeat that. The whole issue of process, I mean, how the speed with which they were able to convene and do the bidding of FunnN. I mean, unbelievable. FunnN to be able to railroad the Supreme Court to act with such dispatch when all the chief imams and imams, all the pastors, all the leaders, all the religious groups have been begging this Supreme Court to take a decision in relation to the LGBTQ question, and the Supreme Court has refused to take a decision. And yet, FunnN alone was able to get this Supreme Court. And that is why people must rethink and think carefully about December 7th and what they are going to do. So I am shocked that FunnN, the Supreme Court allowed itself for FunnN to railroad them, to hasten and violate the Constitution and mutilate it in the manner that they did, because there was no basis for what they did. There's no such agency, there's no emergency, and let me assure you that Tuesday is going to be an interesting day. Tuesday when Parliament resumes, it's going to be an interesting day. I'm serving notice. Tuesday is going to be an interesting day.
If you say it's going to be an interesting day, what should we expect?
I said it is going to be an interesting day.
There was something that you said earlier. So if the courts, based on the references you made, should stay true to its original jurisprudence, the expectation is that the court's mandate in terms of any application brought before it now will have to be limited to determining the correctness by which, or rather to indetermine the propriety by which the speaker exercises his mandate.
Let me give you what the proper position of the Constitution is. Yeah, you see, I am interested in constitutional law. Is that okay? I'm interested. You can go and ask my lecturer, Kofi Kumado, in constitutional law. People say Harvard. No, I didn't learn my constitutional law from Harvard. Yeah, I did constitutional law at Harvard. I got taught by one of the best, Lawrence Pratt, who was Al Gore's lawyer. But for me, the foundation of my constitutional law comes from the teaching of Professor Kofi Kumado, who I'm very proud of as my lecturer. I always take my time and read the wording of the Constitution. And I always ask lawyers, please pay attention, because it is written in English. Is that okay? If the English raises doubts because of application to facts and circumstances, then we can deal with that. But the basic thing is that it is in English. Read Article 2. It says that a person who alleges B, any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution may bring an action in the Supreme Court for a declaration to that effect. For a declaration to that effect. 2:2 says, the Supreme Court shall, for the purposes of a declaration under clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made. Giving effect. Enabling effect to be given to the declaration. So the first thing is, your mandate is not to interfere in the work of Parliament and suspend their decisions. Your mandate is to declare whether or not what Speaker did is in violation of Article 97 1G of the Constitution. Period. So that's judicial review. I get the point. If you so declare, then you can now make orders to give effect. But somebody comes to you and says, "Oh, Parliament went through all these processes and then did some things, and I think it's wrong." They say, "No, Parliament, please suspend your decision. Don't enforce it. Give me time to now make a declaration." It's not ordinary land litigation like Kwebu has tried to explain. Land litigation, and this is a constitutional matter governed by the clear language of the Constitution, because you don't take one clause, Article 2, and so I'm acting on Article 2. You must read Article 2.
Abusuafo nyame show obi otimi ne hwese adwumadiwe ewie ase nyame show obi do obi otimi ne hwese adwumadiwe ase ye shall say on subscribe ya obe subscribe say na ya the new political updated videos bi aba won sabi to me aked na na ya adwuma ye be shall say bibia be cause bi ade bibi be comment section won say na ye be hu de e ko ne de ye ba ye damas.